Imagine stepping into a global courtroom, a place where whole nations stand before judges debating the most serious things you can think of, like genocide. The weight in that room, you could just feel it. And for you, understanding how these huge legal cases play out, it's more than just following news. It's about seeing international justice really working. Today, we're doing a deep dive into a brand new order. Just came out from that very court, the International Court of Justice, on July 25th, 2025. And this order, it's a really key moment in the ongoing case of the Gambia versus Myanmar. You know, the one focused on alleged violations of the 1948 Genocide Convention. So our mission today isn't just to tell you what the order says. We want to unpack what it reveals, about how international law actually operates. How do these big global conventions get interpreted? And maybe the most fascinating bit, how do countries that aren't, the main players in a dispute still get their voices heard? We're going to explore the specific legal hoops these intervening states, as they're called, have to jump through.
Right. And just to give you a bit of background, the main case kicked off when the Gambia filed its application. That was November 11, 2019, alleging Myanmar violated the Genocide Convention. Then, pretty quickly, the court took an urgent step. They indicated what are called provisional measures against Myanmar. That was January 23, 2020.
Provisional measures, those are like temporary orders, right? To stop things getting worse.
Exactly. Urgent orders to prevent more harm or aggravation while the case proceeds. Now, Myanmar initially pushed back. They challenged the court's jurisdiction, basically, its power to even hear the case. And they also argued the Gambia's application wasn't admissible, like it shouldn't even be considered formally.
Ah, okay. So they tried to stop it before it really started.
They did. But on July 22, 2022, the ICJ came back with a decision. It confirmed it did have jurisdiction and that the Gambia's application was admissible. And that ruling, that was foundational. It really paved the way for, well, all the procedural stuff we're seeing now.
Okay, so the main case is set. It's moving forward. And now other countries are looking to get involved. But like you said, it's not just walking in the door, is it? What exactly is this intervention thing in the ICJ context, specifically under Article 63 of its statute?
Yeah, it's definitely not casual. Article 63 intervention is a very specific legal right. It allows a state, one that's also a party to the convention in question, like the Genocide Convention here, to intervene if the construction of that convention is being debated.
Construction meaning interpretation, how to read it.
Precisely, the interpretation of the convention's text. And what's key here is that the intervening state's legal interest, their reason for being involved, it's basically presumed just because they're also a party to that same treaty. They have a built-in shared interest in how that fundamental text is understood by the court.
So if I'm understanding this right, these intervening states, they aren't there to argue about the facts. Like, they won't be saying Myanmar did this or Myanmar didn't do that.
That's exactly right. It's strictly about helping the court figure out the meaning of the Genocide Convention itself.
Why is that line so important, especially in a case dealing with something as heavy as genocide?
Well, that distinction is absolutely fundamental to how the ICJ works, particularly with Article 63. The right is deliberately narrow. It's limited only to interpreting the convention's provisions, not the factual side, not how the convention applies to those facts in this specific case.
Okay.
And this strict boundary, it ensures that these interveners help clarify the law, which affects everyone who signed the treaty, without muddying the waters of the main dispute between the Gambia and Myanmar. It keeps the focus clear.
Right, keeps the main case on track.
Exactly. And we've actually seen this before in this very case. The Maldives intervened earlier, and there was also a joint declaration from Canada, Denmark, France, Germany, the Netherlands, and the UK. The court already found their interventions admissible back on July 3, 2024.
Ah, so there was already a precedent set here.
Yes. That earlier decision definitely set the stage for this new order we're talking about today.
Okay, fascinating. So with that precedent in place, some other countries decided, right, we want in too. Who are the next ones to step up?
Yep, a new wave came forward. First was Slovenia. They filed their declaration November 29, 2024. Then the Democratic Republic of the Congo, the DRC, on December 10th. Belgium followed quickly on December 12th, and Ireland on December 20th, 2024.
Okay, 4 more states. And what did the main parties, the Gambia and Myanmar, think about this?
Well, interestingly, the Gambia, the applicant, actually supported these new interventions. They were fine with them being admitted. But Myanmar, the respondent, objected. They objected to all 4.
Ah, okay, so that's the conflict the court had to resolve in this new order.
Precisely. Myanmar's objections triggered this whole process and led to the July 25th order.
So Myanmar basically laid down the gauntlet. What was their first line of attack, their first objection?
They raised three main types of objections. The first one was about signature requirements, specifically targeting the DRC's declaration. Myanmar argued it was technically flawed because the signature of the DRC's agent, their representative, wasn't properly authenticated by the right diplomat at the exact time it was filed on December 10th.
That sounds very technical, like a strict procedural point. Did the court buy that? How did they handle something that specific? It kind of speaks to that balance between strict rules and, well, reality.
It does, yeah. The court acknowledged, yes, there was an initial defect. The authentication wasn't there right away. But critically, the court noted it got fixed. The DRC's Deputy Minister for Foreign Affairs eventually authenticated the signature on February 20, 2025, and the court received it February 26.
So it was corrected later on.
Right. And the court called this a defect of form, a procedural hiccup that could be and was remedied. They accepted it because it was fixed within a reasonable period of time.
So a bit of practical flexibility there from the court.
Definitely. It suggests they value getting to the substance over tripping on minor procedural hurdles, especially when they get corrected reasonably quickly. It might even encourage other states in the future, knowing there's some leeway.
Okay, makes sense. What was Myanmar's second objection then? You said there are three. This one was about timing.
Yes, timeliness. Myanmar argued that the declarations weren't filed as soon as possible. Now, there was a final deadline for interventions.
Which was?
December 30, 2024. That was the date set for Myanmar to file its rejoinder, which is its last big written argument in the main case. All four states did file before that date.
So they met the deadline. What was Myanmar's argument then?
Their argument was essentially, even if they met the final deadline, they still waited too long. They didn't file as soon as possible after deciding to intervene, and Myanmar claimed this delay would just slow down the whole case.
That's an interesting angle. Trying to interpret as soon as possible very strictly, even with a hard deadline in place. How did the court read that rule?
Well, the court went straight to the rulebook, Article 82, Paragraph 2 of its rules. And it's stressed you have to read the whole thing together. It says a declaration shall be filed as soon as possible, but in any event by the date fixed for the filing of the last written pleading.
The but in any event by part.
Exactly. The court highlighted that phrase. Since all four declarations were filed before that December 30 deadline, the court said, yep, they're timely. It's a very clear interpretation. The in any event by clause sets the real absolute cutoff. It gives clear guidance for future interveners.
Right. Practicality wins again over a super strict reading of as soon as possible. Okay, that brings us to the third objection, the one Myanmar apparently thought was the big one, about the scope of the intervention.
Yes, the scope. This was probably the most substantive objection. Myanmar argued that large chunks of what these four states wrote in their declarations went beyond just interpreting the convention.
What kind of things did Myanmar say were out of bounds?
They pointed to several areas, things like discussing how you prove facts in a genocide case, mentioning the procedural history of the Gambia v. Myanmar case itself, getting into the weeds of genocidal intent, a really complex element, and how you might prove it, talking about the standard of proof needed, and even basing their interest partly on the idea that the Genocide Convention creates erga omnes partes obligations.
Erga omnes parte. Remind me.
It means obligations owed by every state party to all other state parties, kind of owed to the treaty community as a whole. Myanmar felt the interveners were trying to leverage that status improperly.
So Myanmar's point was, if large parts of these submissions are wrong, the whole thing should be thrown out, or at least heavily edited.
Pretty much. Either make the whole intervention inadmissible or significantly restrict what these states could talk about later.
And how did the interveners, Slovenia, DRC, Belgium, Ireland, respond to that? Did they say, no, this is about interpretation?
They did. They pushed back, arguing their points were within scope. They framed their arguments carefully. For example, when discussing intent, they'd say they were doing a conceptual analysis of Article 2 of the Convention, the part that defines genocide and includes intent to destroy, rather than saying, here's how Article 2 applies to Myanmar's actions. It's a subtle but crucial distinction.
Okay, yeah, I can see that. It's all in the framing. So this is where it gets really interesting. As you said, the court has to draw that line very carefully. What did it decide on this crucial scope objection, and did it add any warnings?
It did. The court was absolutely crystal clear. It reaffirmed the core principle. Article 63 intervention is strictly limited to the interpretation of the Convention's provisions. Full stop. Now, it did find that the declarations submitted by the 4 states do concern the construction of Articles 1 through 6 of the Genocide Convention, especially Article 2, with its definition of specific intent. So in principle, they were on the right track.
But there sounds like a but coming.
A very important but. The court issued an explicit qualification, almost a warning. It stated that it will not consider anything in these interventions that goes beyond construction. That means things like the value of evidence, the specific facts of the case, or arguing about how the convention applies to those facts. Those are off limits for the interveners.
Wow, okay, so a very direct instruction.
Very direct. The court added it expects the interveners to refrain from addressing those off-limit topics in any future written documents or, if they get the chance, oral arguments. And one more point. If they refer to other international law, it will only be considered if it's directly relevant to interpreting the Genocide Convention itself, nothing extraneous.
So the door is open, but it's a very narrow doorway focused purely on the legal meaning of the treaty text.
Precisely. It's a powerful restatement of the limited but still important role of an Article 63 intervener. So, wrapping all that up, the court reached a unanimous decision. All the judges agreed. They decided that the declarations of intervention by Slovenia, the DRC, Belgium, and Ireland are admissible. But, and this is the crucial part emphasized in the order, insofar as they concern the construction of provisions of the Convention on the Prevention and Punishment of the Crime of Genocide.
Unanimous and with that very specific limitation. Okay, so what happens next? What does this mean practically for these 4 states and for the case moving forward?
Well, first, these 4 states, Slovenia, DRC, Belgium, Ireland, will now get copies of all the written arguments exchanged so far between the Gambia and Myanmar, the pleadings, the memorials, counter-memorials, replies, rejoinders.
So they get fully caught up on the main arguments.
Right. And then they have a deadline. They need to file their own written observations by September 25, 2025. But crucially, these observations have to stick strictly to the subject matter the court allowed, the interpretation of the Genocide Convention. They can't stray into the facts or application.
And will they get to speak in court later?
The court said it will decide later whether they'll be allowed to make oral observations during the hearings. That's still TBD.
Got it. So the big takeaway here is that these states are joining not to argue the facts of the case, but to help the court understand the legal toolkit, the convention itself, that it will eventually use to assess those facts.
That's the perfect way to put it. Their role is about clarifying the law, the meaning of the convention, which the court will then apply to the evidence presented by the Gambia and Myanmar to ultimately decide the case.
What a fascinating journey through the real mechanics of the ICJ. We've really seen how this global court balances these complex procedural rules with the fundamental principles of international law, allowing states to, chip in on interpreting these vital global treaties, even if they aren't the main parties fighting the case. And for you listening, this deep dive, I hope, shows that intricate legal machinery behind the scenes of international justice. It highlights how every single detail, seriously, from authenticating a signature to how an objection is worded, gets scrutinized. It's all about ensuring fairness and sticking to the legal rulebook in cases that have huge impacts on human rights worldwide. Understanding these procedural steps is really key, I think, to appreciating that bigger struggle for accountability under international law. So the court drew a really clear line here, didn't it? Interveners talk about the law, not the facts. Here's something to think about. What are the strategic ripple effects of drawing that line so sharply? How might this decision shape the way other countries approach intervention in future international cases? Will they be more careful, more focused in their arguments? Definitely something to ponder.